few years ago there, a former president of the High Court, Mr. Justice Peter Kelly, he said that only paupers and millionaires can afford to litigate in the court, or in the High Court especially. And more recently, a retired judge, the High Court judge, Deirdre Murphy, she says that Peter Kelly's quote should be changed from only paupers and millionaires can afford to litigate to only paupers and multimillionaires. The vast majority of citizens do not have proper access to law under the system as it currently stands, said the retired judge, Miss Justice Deirdre Murphy. And she says that it's arguable that the state has a constitutional duty to provide a legal system that gives everybody access to the law. Mr. Justice Peter Kelly, the president of the then, he was the former president of the High Court. When he made his statement, he was pointing out that the cost of litigation effectively meant that only paupers could afford, and people with substantial financial resources can litigate in the High Court. And the reason paupers can do it is because they've nothing to lose. It's pointless pursuing them for any cost orders. Miss Murphy then, this retired judge, she addressed a gathering of solicitors in Naas there in the last few weeks. And the particular gathering is concerned about small and smaller firms, basically small and medium-sized law firms. She also made the point that a ruling by the Competition Authority preventing restrictions on entry to the bar has resulted in about 2,500 barristers for whom there is insufficient work. And she said that when survival is the primary goal, the pursuit of fairness and justice will not be a priority. So she recognises there the struggles and the difficulties for barristers. She also refers to the idea of corporatisation and commercialisation of law, which has reduced law to a great extent to it being a business only and to be transacted on the basis of billable hours. She says that this tyranny of billable hours means young people joining big firms are under pressure from day one and unable to leave the office until they have met their billable hours quota. She raises the question then about the state. The state briefs larger firms, but she's asking why does the state not evaluate that work that's required, nominate a fee for it and invite tenders. She says that state work has increasingly been removed from smaller firms with a knock-on effect on the viability of those firms. An example of the exclusion of smaller firms from state work was the imposition some years back of an €11 million insurance requirement for firms tendering for work from the National Asset Management Agency. I have a firm myself and I don't have insurance of €11 million, and it's not required either for a solicitor or solicitor's firm to have that. But the state imposed that barrier for any work, tendering for work from the National Asset Management Agency, NAMA. She says that a challenge should be put down to the state's briefing policy to achieve more equitable distribution of such work. And she pointed out the danger of smaller firms and independent barristers disappearing, because if that happens, there'll be nobody left to take cases to challenge the power of the state, because the big corporate firms have no interest in doing that. She says the Ireland for Law project, promoting Ireland as a leading centre for international legal services and backed by the state, the IDA and big firms, has encouraged many international law firms to locate here and precipitated mergers with smaller and medium-sized Irish firms. But this international business, she said, is of no benefit to any Irish citizen other than a small cohort of top-earning barristers and solicitors. The government and the IDA should explain how it's proposed to accommodate this business, including whether it will diminish the capacity of the High Court to perform its core function of upholding the law and determining and vindicating the rights of citizens. The only part of this lady's opinion, this lady's talk to this group Solicitors Ireland, organised by Solicitors Growth. The only quibble I would have with her arguments would be that it's not essential for a small or medium-sized firm to be in the High Court. And quite frankly, my experience is that you can make a perfectly good living as a solicitor, certainly as a sole practitioner, by staying out of the High Court, and there's plenty of business still out there. There's plenty of rights to be vindicated. There's plenty of property conveyancing to be done, wills to be drafted, employment disputes to be involved in, rights to be vindicated essentially. So she's a former High Court judge, I understand, and probably has a particular slant or emphasis on the High Court, but my view is that a small firm or a medium-sized firm can get along perfectly fine if without necessarily going to the High Court. And High Court is a high-stakes game, and as Peter Kelly says, and as she says now, only paupers and multimillionaires, quite frankly, can afford to litigate in the High Court. I had an RTB, a Residential Tenancies Board hearing this week with one of my tenants. I had a previous hearing with this same tenant, and he went in at the time in 2022 and he told the adjudicator that I was the best landlord he ever had and he would bring the rent up to date. I was persuaded to accept this as a settlement of the matter, which was suggested by the adjudicator at the RTB, and he brought the rent up to date. But no sooner did he do this than he stopped paying the rent again, and he's not paid since, or at least he's only paid once since. He hasn't paid rent for over 12 months, well over 14 months at this stage, not have been. And the rent he has to pay is very, very small because he's on housing assistance payments, so his contribution to the rent is very small. I was determined this week at the hearing that I wouldn't be fooled or soft-soaped this time again. At this time I just want my property back. I don't think that's too much to ask. In circumstances where the chap hasn't paid rent for over 12 months, 14 months at this stage, then I believe I'm entitled to it. I followed all the steps I'm supposed to follow. I served the various notices of arrears, notices of termination, etc. And as far as I'm concerned, I'm entitled to possession. I already had somebody call to the property and he told the agent that I sent out that he wasn't going to leave until the local authority gave him a house. I may go to the district court eventually if I get an order for possession from the RTB. I probably will have to do that to get him out. But if I do have to go to the district court, I'm going to be looking for my arrears as well. And I know he's working, so I'm going to go after those. I'm just going to, I'm fed up getting taken for granted and taken for a nice guy and being basically taken advantage of. I will go to the district court and I'll pursue him for every cent. Whether I get it or not remains to be seen, but as I say, I do know that he's working. Anyway, that is the story. Residential letting in Ireland is a very, very frustrating activity. There has been a huge exodus from the residential letting market over the last 5 years or so, and that would be one of the contributory factors, in my view, to... So the Trump criminal trial started in New York this week, and it's going to be fascinating. It's expected to last for 6 to 8 weeks, but there's two things that I'm going to be looking for over the course of the trial, if it's allowed to continue. One, whether Trump testifies or not. In other words, gives evidence on oath and is open to cross-examination. If he gives evidence, obviously, and testifies, he will be open to cross-examination, and that should be interesting, to put it mildly. The second thing I'm looking for, though, is the impact on Trump's mental health and his psyche of being confined in one place for full court days, for weeks, 6 to 8 weeks is expected, in an environment over which he has no control. Remember, this man is used to getting his own way. He's used to being king of the castle, and in this courtroom, he's not the king of the castle. The boss in the courtroom is the Judge Juan Merchan, and the impact on Trump's psyche of being subject to that and having to sit in one spot in court for weeks on end similar to a child being put into a bowl chair or a bowl step or whatever in senior infants. That's going to be fascinating. And I don't think it can be underestimated, the effect of that on a person's psyche over a particular period of time, a prolonged period of time, especially when that person is used to doing their own thing. I think his hubris and his narcissism will be big factors in determining the outcome of these two issues. So I'm really looking forward to that, and I'm hoping obviously that the Supreme Court doesn't make a decision that the President is somehow immune from prosecution for anything and everything, even former presidents. That is a Supreme Court decision that's going to emanate fairly soon, because the Supreme Court has taken that case just now in the last couple of days.